I'm going to move quickly through these slides to give you maximum time for questions. You'll come to understand that whistleblowing is not as simple as you may think it is as we move through the presentation. That's a great picture of me wearing my Ukraine pin. Everybody should be focused on the Ukraine. It's time to win the Cold War. Next slide. Disclaimer, I'm required to disclaim because I'm still under a non-disclosure agreement with the Office of the Director of National Intelligence. So nothing that I say today should be attributed to Avril Haines, the DNI, or anybody in her agency, including the Inspector General. Next slide. My CV, just not really to impress you. I do want you to understand that part of the reason why I ended up in the whistleblowing law field is because I was a whistleblower myself. I was commissioned out of Cornell University as a young ensign in 1987, went to the battleship Iowa, was on the Iowa when she had the explosion in Turret 2 in 1989. 47 of our shipmates died, and to my horror, the Navy shore establishment proceeded to blame one of our shipmates for the explosion. That turned out to be a crock of cheese. And my men in Turret 1 were able to move information to Sandia National Laboratories that eventually found the cause of the explosion to be the gun system itself. If you go to the next slide, after representing whistleblowers, I went back into the federal government, and in that capacity, I was asked to set up the first civilian reprisal investigations program inside the Department of Defense Inspector General Office. The idea was to bring the best practices of the Merit Systems Protection Board and the Office of Special Counsel into the IG system. In that capacity, I was a whistleblower late in that tour, in part in concert with my supervisor. On the question of whether there was an unlawful disclosure regarding classified information to the producers of the movie Zero Dark 30, done for political reasons to enhance then President Barack Obama's re-election profile. And then also at the same time, I was handling an investigative misconduct allegation regarding the Afghan National Hospital, military hospital in Kabul, where the allegation was that doctors were shaking down families for bribes under the threat of throwing their sons off the roof of the hospital and killing them. Pretty disgusting behavior. Both of those brought me to the attention of the intelligence community. I moved in to set up their whistleblowing program, the program you know as having handled the Ukraine whistleblower after I left that position. And in that capacity, I was a whistleblower again against the acting inspector general, who was alleged to have committed violations of PPD 19, which is a whistleblowing directive from the president for the intelligence community, and also other matters of corruption related to time and attendance. Then moved into private practice, worked for Compass Rose for a bit, came to Tully Rinckey, and I've been here at the firm since 2018. Next slide. That's the overview slide. Okay, let's go to, I like to use this slide when I was doing outreach in the intelligence community, because I want to help people understand that whistleblowing is not about your private rights. It's not about self-articulation. It's not about the First Amendment. It's not about any of that, okay? If you're in Article 2, you're in the executive branch, or you're a contractor to the executive branch, your whistleblowing is done as a part of a government system. And a quote from Madison nails it right on the head, which means that if you're going to have a popular government, which is what we have in this country, right? We don't have a king, we don't have a queen. The people are sovereign. And that's not a joke. It says we the people on the document for a reason. Then the people need to be informed. And how do they get informed? There's a variety of ways: C-SPAN, televise the floor debate in the House, and the requirement of federal employees and contractors to blow the whistle. It's a requirement. It's not a luxury. It's not a nice to have. It's a requirement. The second part of that is that the transparency that provides, to be able to see the wrongdoing, means that you get rid of that ability of the federal leadership in particular, supervisors and managers and their attorneys, to use opacity, okay, to cloud the public's ability to see what's going on, to cover up incompetence. Okay, this is about government performance. So when you're thinking about being a whistleblower, approach it from that perspective. And if you're doing it for some other reason, putting the screws on your boss, well, understand that the way the system will treat you is your information valuable as a disclosure about the wrongdoing? And not going to promote your putting the screws on your boss. And that can sometimes be an eye opener for many employees. Next slide. So the law in this area has been pretty stable since 2012. There are some statutory and regulatory changes in 12, except in the financial services field, which is a sort of a boutique niche of whistleblower protection. And then states have been moving forward fairly progressively for a while. California's had some case law that's enhanced their whistleblower protection law, and New York has had some modest reforms. Next slide. Okay, so for the whistleblower, and this is, I think, important before you come to a law firm for help, understand that the game is empirical. It's about the facts in the first couple of quarters of the game, okay? So what you have in the way of facts will determine how well you do in the processing of a whistleblower complaint. There's not a lot of fancy law to throw at an agency very early on. So what the whistleblower needs is, if you're looking for legal services, an attorney who understands the law and can help the whistleblower package the facts that allow either an inspector general or the Office of Special Counsel to move forward with an investigation. This is hard because many people come to lawyers after they're locked out. You're probably not going to have access to your email at that point, folks. So the prudent employee, seeing things go to the handbasket around them, is going to step back and say, okay, what evidence do I have that I've made a disclosure? What evidence do I have that my boss has knowledge of that? If you do that proactively, when you do go to an attorney, it will be very easy to put your case together. Otherwise, you're depending on an administrative investigator at an inspector general's office or an attorney investigator at the Office of Special Counsel to go and get the facts for you. And there are all sorts of institutional reasons why that may or may not happen. If I was running the Office of Special Counsel, it would happen more often than not. But there are restraints on some of these institutions. So it's best if you have your facts. And that's why it's empirical rather than law-driven at the beginning. Eventually, there is need for fine legal arguments. The other two bullets I think are very important is that Title V led the way, but we'll see later on that there's several different provisions for whistleblower protection in the U.S. Code. So you need to know what law pertains to you. And that's determined by your status within the federal system. And then if you're wholly private, then you have to understand what law is not available to you and then also what provisions may be there. Also, I always think it's best to have a congressional friend, but you have to understand the limits of what Congress will do. Congress has lost a lot of its ability to hold hearings. They're kind of flabby in that regard. They don't do it like they used to do. And a lot of the congressional investigators were laid off in 1994. They moved over to the inspector general offices pretty much. So Congress doesn't have the kind of power, investigative power exercised that it had 40 years ago. And then also understand that within the executive branch, there's certain privileges that exist to the president. So if you have a security clearance, you're under certain rules. If you're in an agency that has a regulation regarding your communications to Congress, you need to follow that regulation. That becomes the minefield you need to navigate. It's good to have a friend who's done this before, if that's the case. But all of that are just the game board parameters to the central observation, which is it's the facts in hand that are going to drive your case. And I have worked with a lot of whistleblowers who are absolutely convinced that they had a really great case, but all of their facts were just what they said. And that gives you one fact. Oh, Johnny said X. Well, how do we corroborate that? Journalists have to get 3 sources, most IGs 2 to 3 sources. If you can't come up with number 2 and 3, you ain't got a case, people. Okay, next slide. So this is a reminder of why the process exists. You want to get information to the sovereign, the people as sovereign. People vest their sovereignty in the Congress. The Congress is Article 1 of the Constitution for a reason. The president's Article 2, the second part of the Constitution for a reason. And the courts, the least dangerous branch, are Article 3 for a reason. So sovereignty is vested in Congress, and the executive branch assists Congress in its job of determining the standards by which the government will be run by generating the knowledge of how things are working out. What does the performance of the government look like? And in that regard, the disclosures that are made by individuals that go to the special counsel or go to an IG or go to a congressman, or if you're not under a security clearance and the information is not restricted in the press, that's a bona fide way for some people to make a disclosure. The theory being that the article is read by a member of Congress and therefore there is going to be a correction of the problem. All of that is the question of what knowledge do we have about the government's performance? So this is not about First Amendment rights. It's not about your self-articulation, your self-worth. Nah, that's all for standing on the street corner and haranguing your neighbors about your political views. That's protected. The government can't restrict that. But it's not whistleblowing. Next slide. So just as I just said, this is about being sources to an inspector general, the Office of Special Counsel, or law enforcement. The other thing to keep in mind is that federal employees are trained at Title VII, the EEO laws. So that's where the bulk of our training goes for our employees and for our contractors. So people will understand their rights as they fit into one of the categories of the Civil Rights Act, okay? So you have certain rights in the workplace because you're disabled, because you're aged, because you're a female, or because you are a person of color, or a person of national origin, all the different what are called suspect categories. And they're not suspect because the categories are suspect. They're suspect because people's decisions about other people based on those categories are considered suspect. So we understand that. That's the EEO world, okay? And lots of people get training in the workplace on that. People get very little training of quality training regarding whistleblowing. And there's a reason for that. What you do as an employee has nothing to do with who you are under Title VII. How you do a particular task has nothing to do with your race, your creed, your gender. That's why that system works so well. The people who make decisions based on that need to be punished because it has nothing to do with the mission of the federal agency or the contractor working for the federal agency or the service member advancing the mission of the Defense Department. But whistleblowing is directly about your boss, typically. It's about the performance of the government. So while it's really easy to support the EEO laws, it's hard for a member of the senior executive service or an agency head or agency counsel to love a whistleblower, okay? Senator Grassley calls them the skunks at the picnic for a reason, because you really have to work with senior executives, and I've done this with them, to have them understand that this is about protecting sources. This is about correcting wrongdoing, because in the end, they want to go in and they want to hammer the whistleblower. It's instinctive because somebody is snitching on them. And I have advised federal officials right up to one level below the president on protecting whistleblowers. And my standard line, when I got called into the front office, they knew there was a whistleblower. I'd look at the head of the agency and he'd sit on your hands for 2 weeks. Don't do anything. Cool off, okay? After 2 weeks, if you think there's some bona fide reason to take down that whistleblower, okay, get your counsel in and go forward. But the smartest thing to do is nothing at first, just to let it pass over, and so you can be calm, cool, and collected about your decision making. Next slide. This was a slide I used in training intelligence community whistleblowers to understand what their disclosure was all about. It's an internal ratchet function, okay? This is about making disclosures about internal and external threats to the federal government, or if you're under like the financial services statutes, to our system of stock trading. Basically, that's what the Sarbanes-Oxley is all created for. So you report the external threat, you drop it off, and you detach your identity from it. The worst thing for a whistleblower is to attach their identity to what happens after they make the disclosure. It's a nightmare because, the system will probably never do what you want it to do. But you make your disclosure, then there's a reaction. Hopefully Congress nudges it along. There's some resolution of the issue, and then the system operates better. That's the idea. Think of Joe Darby and Abu Ghraib during the wars in Southwest Asia. There was a system where whistleblowing worked exactly as it was supposed to. And then the process starts all over again. That's why this is a ratchet going round and round and round. Somebody else finds something wrong. Let's get that in and let's see if we can correct that problem. I used to tell federal employees that you should be able to list on your self-assessment for your performance evaluation how many times you blew the whistle in the last 6 months. Okay? Every employee should have 2 or 3 disclosures in the last 6 months. That's a healthy system. But for that system to work, supervisors and managers can't be, Neanderthals and go pounding the poor employee after it happens. Next slide. All right, moving quickly, let's talk a little bit about some of the laws and regulations. I've already mentioned that it's an obligation under Executive Order 12674 to disclose waste, fraud, and abuse. I got in a fight with the Office of the General Counsel in the Pentagon for 3 years. It went on where we fought about the definition of that word shall. They kept trying to find a way of reading it so that it was optional. No, it's mandatory. May is optional. You may disclose. Okay, I can do it if I want to, but I don't have to. Shall means if you know there's wrongdoing, you're going to report it. That's what's required. You're breaking the rules if you don't do that. So, and that's been that's George Bush, the father, signed that document back in 1989. So it's been around for a long time. So next slide. Well, I'm going the wrong way. There we go. All right. So one thing to remember is the category of the person dictates what part of the code applies. I'm speaking about Title V standards in this because that covers most of the federal employees, but there are variations in other whistleblowing systems. Service members under 1034 under Title 10 have slightly different standards. Generally, the analysis is the same, but there are some differences. Title 32, these are reservists, will be covered and not covered at certain times during their efforts with the federal government. Security clearance holders in the intelligence community are under a variety of regulations, and Title 50, the standard's a little weaker for them to protect our covert and clandestine operations than they would be for Title V employees. The contractor provisions that were passed originally in 2012 have not been as robustly enforced as I would have liked. There's hope. They're well written, but they're always worth pursuing. Financial service statutes, very different system. And then we have to remember that the FBI has its own system. I'm not a big fan of it. I think it's bleak house for many of our special agents. And then you also have to remember that OSHA has a whistleblowing program that's covered by 21 or so statutes that involves federal activities. So if you're a state employee and you're operating under a federal grant, or you're a private company that has an obligation under a safety and health statute, then there are specific laws for that run up through the Labor Department. And then private sector employees may be covered, even though they have no connection to the federal government if they're not a federal contractor. That depends on the laws in your particular state. I'm very familiar with the California whistleblower protection law. I worked with then State Senator Hayden to write that statute almost 20 years ago now. And then New York has a very progressive law now. It didn't 20 years ago. Some states have none at all, but even in a state with no statute, there might be a public policy exception to the wrongful discharge law in that state that could be used. But in general, you should know whether you're protected before you get into a situation where you need the protection. Next slide. I developed this one to train the intelligence community personnel as well. My boss hated this slide. All this slide seeks to explain to you is that the coverage under various systems is going to overlap. Okay, and so some people will be under Title V, some will be under Title 10. Intelligence people will be under PPD 19, and then there's Title 50 provisions now. So sorting through that can be very difficult. So be very careful when you're reading something, for instance, on the internet. It may or may not apply to you. Next slide. This was one of Director Clapper's favorite slides. This was a effort we mounted after the Snowden leaks in 2013 to help people understand that there's a lawful process of whistleblowing and there's an unlawful process of leaking, and you need to stay out of the red and stay in the blue, especially if you're operating under a security clearance. Several of our agencies went through a very nasty mess in the last decade, NSA in particular, where employees were not understanding, or they did understand and decided to break the rules anyway. So if you're going to get protection, you're going to act lawfully, and you need to know how to make your disclosure in a way that doesn't set you up for an attack by the agency. Most whistleblowers go down because they gave their detractors a weapon to take them down. So just be smart and prepared up front. Next slide. So there were some changes in 2012 that I'll keep emphasizing going through, even though that was over a decade ago. It was the last big change, but it's very helpful to understand your protections in the workplace if you understand what the Whistleblower Protection Enhancement Act of 2012 did. So the first thing it did is it got rid of the agency foil to try, they had successfully bottled up whistleblower protection by saying that disclosures made to the wrongdoer or to a supervisor weren't protected. That's no longer the case, but you need documentation. Just saying it to the person and then putting that in a declaration later on, that's only one piece of evidence. It'd be better if you documented it in an email and save the email. Try not to use text with your supervisors. One, they're not very secure texts. Lots of people can see those. And two, it's harder to get that evidence off the machine. And the best evidence is saved in your own personnel file. And you want to be careful with classified but controlled but unclassified information now. There are special rules about that. But by and large, if it's FOUO, okay, or it's CUI, you can have access to it for whistleblower protection. You just want to be careful how you handle it. And then the other thing, the repeated disclosure foil got taken out. If you repeat a whistleblowing material, or you're repeating what somebody else said, that's protected now post 2012. Next slide. All right. So other things that were important changes in 2012 that are helpful in understanding the workplace as it exists now. We don't care about employees' motivation. You'll hear that from managers all the time. Oh, they have an EEO case, so they're coming after me with a whistleblower case. That may be what's happening, but Congress doesn't care. Because when Congress passed a law, they said, we're taking the employee's motivation out. What we look at is the supervisor's motivation in reprising. Disclosures not made in writing used to not be protected, but they are now. But let's also remember that if it's oral, it's not, it's going to be your statement, and there's not going to be a second piece of evidence to confirm it. Off-duty disclosures were a problem for people, particularly in law enforcement. Delay in making the disclosure was once considered a problem. It's not so much now. Uh, Disclosures in the normal course of duty. If it was your job to report wrongdoing, this really, once I pointed out that 12764 required whistleblowing, it became a real problem. Everybody said, well, yeah, under that executive order, they're required to do it, and that's in the normal course of duties. So the statute clarified that. And then disclosures about censorship related to research, analysis, technical information. That was a pet provision of somebody to get in the statute, but it does underscore a very important point. The first question to ask yourself when you've made what you think is a disclosure is, what law, rule, or regulation did it violate? And if you can't point to a law, rule, or regulation that's been violated, I know there's other standards in the statute: gross waste and mismanagement, abuse of authority, et cetera, substantial risk to public health and safety. But all of those come back to what rule was violated. And I make employees go back and say, we got to find the rule. And that requires you to get on the website, look at the instructions that govern how you do your job. And many of our federal employees really haven't looked at those instructions in a long time. Next slide. So a very clever point that really drives supervisors and managers kind of crazy, but it's your reasonable belief that there's wrongdoing. So you can be wrong and in the right with whistleblowing. So your disclosure can actually be wrong. It can't be false, but you can be mistaken and you still get protection. Even more interesting, the disclosure can be wrong and you can be thought to be the whistleblower and somebody else did it and you still get protection. So the whistleblowing can be wrong and the manager can be wrong about who did the whistleblowing and the person still ends up protected. That's been the case since that statute passed. Next slide. Okay, it's important to understand the rubric that you're under. And we talked about that a little bit earlier. What title are you under? Most federal employees under Title V. You're in the military, you're under Title 10. Next slide. So what are you looking for in a rubric-based complaint? Okay, so you've made a disclosure, you're about to make a disclosure, you're thinking about doing a consult with Tully, Rinckey, or one of our competitors. And okay, what do I need? I need the best attorney who does this work. Well, and attorneys love that kind of thought because they're all going to put themselves out there as the best attorney. Now, that's not what you need first. You need the best attorney when you get, say, in the OSC process, you get into it and you need to make a legal argument after OSC's made some decisions on your case. That's the time to have a really great attorney. A good attorney for you at the beginning is one that can coach you on the empirical process, okay? And I developed this after my time as a federal investigator. I took a break from practicing law for almost 20 years. My job was running investigations. And when I got ready to go fight for a finding in the front office, I had to be the lawyer for my own investigations, and I was pretty good at it. But prior to that, I needed investigators who could develop a case. And that's what the special counsel needs when you file with the special counsel. And that's what an IG needs when you file with an IG. And frankly, it's what the judge needs first and foremost when you file with the Merit Systems Protection Board, although the law is much more important at the board level. So what's a good package to go forward? Well, you're going to fill out the forms, or probably should have an attorney fill out the forms. But what are going to get attached? You want a really good chronology, and you should be keeping this right now. I think everybody should. I had a boss, Don Horseman. I was a senior official in the Office of the Inspector General, and Don kept a chronology of everything he did every day. It was so good, we saved it on the common drive when he retired, so we could all go look at his chronology and remember what we did 10 years before. So a good chronology is helpful. And then if you come to me at Tully Rinckey with a whistleblower case, I'm going to have one of our associates sit down, go through that chronology with you and me, and we're going to color code. Where's the disclosure? Where's the adverse action? Where's the knowledge? Where is there evidence that the agency could have acted and not have this be reprisal under the clear and convincing standard? If you color code your chronology, you've got a good sense from the get-go whether you have a case or not. And if you do it beforehand and you see that, I got reprised against, and then I made a disclosure 2 months later, that's not going to fly because the cart's before the horse in that scenario. So then you're going to need to write a personal declaration written from that chronology. Why do you do this? Because you're beginning to tone up your memory for when you have to speak to an investigator, right? An investigator is looking at you for your credibility. They want to know what you know, but they also want to know how you deliver it. And they're going to be watching you as they do a clarifying interview. And if you come across as squirrely, they're going to label you as squirrely and your case is going to suffer. So writing out your declaration, getting the details down from the chronology is very, very important. And it's very helpful to have an attorney who's a whistleblower expert to help you with that part. Then any exhibits that you have squirreled away are great to attach to the chronology, which is attached to the declaration. I was in a very controversial, tense relationship, a professional relationship, with a former boss who was an acting inspector general, and I kept my evidence in the trunk of my car in a portable filing cabinet, and I parked my car right below his window, and I would open up that boot of my car and open up my portable file drawer, and I would put emails in there that I could lawfully keep. They weren't classified. Right as he was looking out the window. So he knew the whole time we were having our tense 8 months or so that I had the goods that was sitting there right in the boot of my car. So having that together so you can attach it as exhibits for the special counsel or for an inspector general is a good thing. They own the records. They can go get them. But whether they're going to go get the record, whether they're going to seize hard drives and go poking through federal officials' emails is going to be based on the case you bring to you. And if they don't think your case can go away, and so they can leave at 2 o'clock in the afternoon, they're going to follow through. But that's going to depend on what teasers you can bring to the table at the beginning. I'm a big believer in what's called the reprisal matrix. I think and this is really, I've tried to have clients work on this. It's hard because a reprisal matrix is basically the law of whistleblowing and then the evidence parsed out next to it. You can tell whether you have a winning case once you get the reprisal matrix done, and you can use the matrix to show the investigator at OSC or an inspector general's office where they need to go get the evidence. And it's a very helpful tool. And then congressional interest is always helpful, but don't expect your congressman to weigh in on your side, okay? The artful congressional staffer will put together a letter that says they're interested. We'll ship it off to OSC or an IG, and they'll ask for a 30-day update. That's what you really want. You want the Congressional Affairs Office inside the Department of Defense Office of the Inspector General to have to go to the IG every 30 days and say, oh, we owe Senator Wyden an update on Paul Smith's case. Every 30 days, the investigators have to go up and brief the IG on what's going on. That moves cases a lot faster than if you go in with no congressional interest and they just throw your file on the credenza and I'll get to it when I'm done with the holidays. And then the legal argument's important when you have to fight about the application of the facts to the evidence. If there's one slide to remember from this presentation, it's this one, folks. It really is the key to winning a case. All right, next slide. I'm going to skip over this one. It's about whistleblowers with access to classified information. This is PPD 19. That's now codified in part in Title 50. If there's questions on this, I can take them at the end. Next slide. Always remember the doctrine of an investigation as a pretext for reprisal. I think it's very important in disciplinary proceedings under Title 5 in particular. If the investigation's a pile of junk, okay, and a lot of administrative investigations are a pile of junk. If it's reverse engineered to get to a predetermined decision, if there's been selective interviewing of witnesses so as to shape the evidence against the subject of the investigation. My times with the IGs, about a decade and a half, I saw just awful investigations where somebody just got a burr under their saddle and they went charging off and they just crafted the evidence against the poor person. In that situation, that can be, the investigation itself can be the reprisal, but some adverse action has to be based on that investigation. Still haven't gotten the law changed so that you can go after the investigation itself. I'm hopeful at some point before I retire that that will end up as a change in the law, because I think it would get our investigators under control, because often they don't have enough oversight. Next slide. Prima facie case for a whistleblower case using Title V. Did you make a disclosure? Were you the subject of an adverse action? And then was the disclosure a contributing factor in the adverse action? Not all communications are disclosures, okay? Your policy preferences are nice. They're protected in the First Amendment context. But the fact that somebody chooses to do this policy option rather than that policy option is not going to be found to be whistleblowing. So again, look for the law, rule, or regulation that was violated. Adverse actions, just because your boss was grumpy, if they were equally grumpy to everybody else, that's not an adverse action, okay? And so you got to be careful. You got to find things that are adverse actions. Letters of reprimand, substantial change of pay and or substantial change of duties. Okay, if you get punished by sticking you in a pump room. Okay, I had a client who was stuck in a pump room. That was his new office with no duties at all, with leaky pipes and everything. But you want to know what is an adverse action, and that's something you work on in your chronology, so that you know exactly what you can take to OSC or an inspector general to carry the day. Next slide. We've already covered that. Next slide. Preponderance standard. Just understand that you need to meet a basic threshold of your proof when you go in the door. Go into the Office of Special Counsel, they're doing a preliminary inquiry. They're not doing an investigation when you go in the first time. Okay, they'll decide after about a year whether they'll do a full investigation. But what you can bring to the table, the teasers you can give to them, will help them go out and develop the rest of the evidence. Next slide. Just a simple graphic. This was actually designed by Andrew Buckeye when he worked for me. He's now the managing partner over at Compass Rose. And we used it to brief investigators on what they were doing. So it started at the top from intake down to first and second stage review in a whistleblower case. The amount of evidence you need gets bigger and bigger and bigger the deeper you get towards a substantiated finding of reprisal. And so you can go forward with a very small amount of evidence at the beginning, but by the time you get to the end, where the agency's got a burden of proving clear and convincing evidence, it's a heavy amount of evidence. It's a big pile of paper. In general, the judges at the Merit Systems Protection Board generally fail the federal government at the second stage at the end. And a lot of those cases are artfully disposed of without really holding the agency to that burden of clear and convincing evidence. It's where the statute has failed over the years. So you need really aggressive lawyering at that stage of like an MSPB case or even at the Office of Special Counsel to keep your case alive and moving. Next slide. And then the last part, element 4, breaks into 3 prongs at the end. And it really is the element that decides most whistleblower cases. The agency can take an action against you if it has evidence to show that it would have taken that disciplinary action or that adverse action against you regardless of the whistleblowing. Element 4 in the next slide breaks into 3 prongs, okay? And artfully done, you can take an agency down with these 3 prongs. Was there support for the action? This is the rule in Carr. Carr was a case. And support for the action doesn't mean that the official had authority to do it. For many years, under Title X, the Inspector General of the Defense Department, the investigators would just say there was support for the action if there was authority to take it. So there had to be an instruction that said you could take the action. That's not the analysis. They did the cases wrong for many years over at the IG's office. The support prong means that not only was there authority to do it, but they followed the rules in the way they were supposed to. Okay, this is the due process element inside there. So you need an attorney to go through, and you need a good record of what's been going on so you can find out whether there was some effort to undermine a whistleblower by not following the rules. Investigative misconduct would come under the support prong. Motive, you don't need a smoking gun to show that a supervisor or manager had motive to reprise. But the closer the disclosure is to the actions of the acting official, the more likely that a person making a decision on whistleblowing is going to find motive. And then the last one is really important, and it's the comparator analysis. The agency needs to come forward and show, and frequently this is where judges let them off the hook, and maybe your lawyer needs to demand that they actually show that similarly situated employees who were not whistleblowers, okay? A lot of people thought, oh no, we have to go look at all our whistleblowers and see if they're being treated the same way. No, that was crazy. I mean, yeah, we fired all the whistleblowers, so we're doing fine under the car test. No, you're looking for other people who were given a 5-day suspension for time and attendance abuse and seeing if in that subset, the people who were not whistleblowers were treated different than the whistleblower. And the way we used to do this when I ran civilian reprisal investigations, I'd have my team do spreadsheets, and then we'd stick it on the wall on the other side of the office from my desk. And then if you were treated one way, you got the green box. If you treated another way, you got the red box. You were green blocking or red blocking. And if the agency had more red on that page than green, then I found reprisal. And then it was really tough what happens if it was split half and half. You got to do a little bit more analysis. But getting the comparator analysis is the agency's job, and you've got to insist on it because it's absolutely essential, I think, in winning the fourth prong, the fourth element, which is divided into 3 sub-prongs. Next slide. Clear and convincing is just it's the higher level of proof that the agency is held to. So just think of it that preponderance is 4 inches of paper and clear and convincing is like 18 inches of paper. That's the best way to think about the standards of proof there. The role of comparators, next slide. The rule in Williams, which came out in 2009. This has been going back and forth. It's been an EEO ruling issue. But how you look at comparators and who's allowed to be seen as a comparator is very, very important. And so not allowing the agency to control the characterization of the evidence is very important. Your attorney's got to get in there and make sure that you're getting the broadest possible classification of employees for that fourth element that's divided into 3 prongs. Next slide. This is a slide back from my work in intelligence community whistleblowing. Joe Darby on the left is the model whistleblower. He did the right thing, slipped a piece of paper under his first sergeant's door about the abuse in Abu Ghraib. The Bush administration got the allegations probably about 3 months before they became publicly known. And the problem was pretty much fixed before everybody found out it existed. That's whistleblowing at its finest. Whatever Edward Snowden was doing, I can't say too much about this because I have read the classified report, but whatever he was doing, that was not the right way to do it. I have a personal beef on this, and that I was the person he ought to have come to in the Defense Department when he thought he had a problem. And if he had given me the laptops, I would have walked him across the hall to Mike Decker, who was the Assistant to the Secretary of Defense for Intelligence Oversight. And Mike and I would have figured out a way to get the issues fixed and get him protected. But instead, he went on a trip to Hong Kong, ended up on the Neva River in Russia. Next slide. This is a little bit of a wonky academic slide, but one that I think about in cases when I'm handling a whistleblower. 4 variables juxtaposed against each other: transparency and opacity on the central axis, center axis, horizontal axis, and then prudence and candor on the vertical axis. All whistleblowing falls amongst these 4 choices by an individual. Reporting to an IG or a special counsel or Congress is right down the middle. It's a balancing of all four. If you go too far in being prudential or opaque with the handling of this type of information, you're covering for the agency. The wrongdoing is not going to get corrected. And too much transparency, you're going to make an unauthorized disclosure and you're going to end up in prison. Okay, that's where you go. So it's very important to understand how these four values are moving in any situation. And knowing where your boss stands on these is very important, because that will tell you whether you're in for a controversy or not. Next slide, very controversial slide. When I used to do outreach in this area, I used to point to this group as people who did the right thing and the wrong thing regarding whistleblowing. Joe Clark, Ambassador Wilson, Joe Darby, Mike Vickers, Leon Panetta, they all made disclosures that were safe and protected, and they were at a variety of levels of seniority. The unsafe, and some of these people I think the world of. Jeff Sterling on the right side was a CIA whistle. Well, he ended up being a leaker, and they went after him because he didn't make it in the right way. Snowden, we talked about. Chelsea Manning, John Kiriakou, and I've forgotten his name. That's bad of me. Tom, and NSA, who frankly did not make a disclosure. Did not make a leak. There was nothing in the alleged leak, and it ended up being a really sort of tragic prosecution. I think he was badly treated, but he proceeded in a very risky manner. And that was all about electronic monitoring up at NSA. So last slide. That's what we want all whistleblowers to be treated. Ted Kennedy getting ready to do honors for Joe Darby after the Abu Ghraib scandal. And then the takeaway, and this will leave us with a few minutes for questions. The key takeaway is prepare up front. You want to be able to collect your evidence and have it available for your attorney if you want to blow the whistle. If you're already knee deep in it, you got to figure out how to do the best you can, given that you're 2 or 3 years behind the curve in getting your case together. And then I think the last one is for questions.
If there are any questions for Dan, please send them via the chat. There were a couple pre-submitted questions, so Dan, I'll send those over to you now.
Okay. All right. Here we go. Is that it? What evidence best supports reprisal? How should you approach future communications with leadership? Well, the best evidence is one that ties your observation to a law, rule, or regulation. Then in the recorded evidence, there will be some reference to the standard that you were making your decision based on. So if the rule in the agency is that telework requires a written agreement, and you say to your boss, I've been reviewing the personnel files of our staff, and Sally does not have a written agreement. Okay, you'll be able to go to the regulation that says written agreement is required, and that can be matched up with that email, and you've got a great disclosure. Should the boss go after you for turning in Sally because Sally was doing something other than teleworking with the boss? That was an actual case. Next slide. Is it possible to blow the whistle even if your supervisor has sent you a proposal to leave letter? Well, that's getting the cart before the horse. Because there's already a proposal out there, but you can blow the whistle. The evidence can be diminished a bit because you already knew this was coming down the pike. So it would have been better to have a disclosure prior to that. What I usually tell people is think about your communications prior to the proposal to leave letter. So a lot of people will overlook a disclosure that occurred maybe 2 or 3 months before. If you're getting a proposal to leave, chances are you've communicated disclosure prior to getting it. And that's the first thing to do, see if that's out there. Can unauthorized recording of executive meetings be used as a form of evidence? Oh, I run into this one all the time. The Defense Department actually started issuing regulations about this after I used it in a case very successfully out in the Midwest. So you got two levels you got to operate at. First of all, an unauthorized recording, it's got to be legal in the state that you're acting in. Okay. So if you're in Virginia, or you're in Maryland, and the person you're talking to is in Virginia, one's a one state jurisdiction, the other is a two-person jurisdiction. So you could be violating the laws in one state, even though you're adhering to the law in another state, and that's going to come back to bite you. But even if the state allows for one person approval, that you can just tape meeting, you have to know what the rule is with your particular agency. Okay, I know for a fact the Army has issued a regulation that they can fire you for taping without approval. And then it has to be done in a way that is not against rules about recording devices inside the agency as well. So you have to be very careful with recordings. Don't use them unless you've got a legal opinion first, because that could be absolutely catastrophic to your case. Why is the whistleblower agency and the Postal Service not under the same type of federal government? Well, the Postal Service for many years has had unique jurisdictional authorities from Congress. It's not that they're not under the same type of federal government. It's just that Congress, when they established the rules for particular agencies, decided to place some in one part of the government and some in another. Some agencies are more independent than other agencies, and the special counsel was only given authority over certain agencies, FBI. Well, some of it might fall under OSC now. It's an open question. But the Postal Service was exempt. FBI has been exempt. The intelligence community, generally, the special counsel has no authority there. And usually that decision is because there's some authority issue within the agency that's being given the break that they didn't want to disturb. So for instance, not putting service members under the special counsel was done to respect the chain of command. And so a system was set up that would operate like the equivalent of the special counsel and still preserve the chain of command. The Postal Service, it's historic. And so that's why it was arranged the way it did. I don't think it's helped the Postal Service. And then, can you touch on whistleblower retaliation? Well, that's what we've been doing for this entire discussion. Whistleblower retaliation is when you go after somebody having made a disclosure. So back to the elements I pointed out, the 4 elements of reprisal. Reprisal is retaliation. You have to have a disclosure. You have to have an adverse action made with knowledge of that disclosure. And then once that prima facie case has been established, the agency comes back and it's allowed, this is the break for the agency, to show the judge or the investigator, we would have taken that action. This is what you're calling retaliation. We would have taken it against that individual for this reason. And then I'll give you a simple example of it. If you've committed time and attendance abuse of an hour a day for 6 months, and someone issues a 5-day suspension for your TNA practices, it doesn't matter whether you've blown the whistle or not, because you handed the weapon to the agency to take you down. You didn't show up on time for 6 months. So, that's whistleblowers have to be as pure as the driven snow. Because if you give the agency the weapon to take you down, they will take you down. All right, when requesting a FOIA, can that be used as evidence to prove the adverse action was too harsh a punishment for someone that didn't blow the whistle? Well, yeah, if you can get the FOIA back in time. FOIAs can take a very long time. There's a colleague in town who had a FOIA that he put in 17 years. 17 years it took them to reply and get him the information. Proving the adverse action was too harsh a punishment for someone that didn't blow the whistle, that sounds like a standard federal employment disciplinary action. And it is helpful to have comparators in that situation, that other people were treated differently. And that could be handled under what's called the Douglas factors analysis, but that would be helpful. But just be careful. The FOIA process is great for the long game. It's not very helpful for the short game because agencies typically take a long time to process FOIAs.
I believe those are all of the questions, Dan.
Okay, well, great. Thank you, everybody, for attending today, and I'll do periodic updates on this topic.